Ladies and gentlemen, to welcome you to this penultimate webinar and event of the BUL International Law Group. The Brunel University London has the pleasure to organize this webinar on the important topic, as we have seen the last 2 years at least, of public health and international law. We have an important line of speakers, both on both sides of the Atlantic, which are going to elaborate more on the topic. The event is being chaired by Dr. Pin Lean Lau from Brunel University London. And for this reason, I'm going to pass now the baton to her in order to introduce the speakers. Just for your information, to tell you already that in essence, the speakers will speak about 15 minutes, 5 minutes dialogue between us will emerge afterwards. And then, of course, you, the audience, you have the ability and the possibility to pose your questions in written in the Q&A section of this Zoom room, not in the chat, in the Q&A section. And of course, as always, the event is being recorded and you can watch it also afterwards in the Brunel Law School YouTube channel. With this, I pass the baton to Dr. Pin Lean Lau, and we look forward to an interesting discussion.
Thank you very much, Dr. Solon Solomon, and thank you very much again to our stellar lineup of speakers for being here with us today. I think this couldn't have come at a better time, dealing with questions about public health, global public health specifically, and its intersections with international law. And I think, a lot of people might think that we're actually coming out of COVID-19, but I actually think it's still an ongoing process. And if anything, it has shown us over the last couple of years how unprepared we are as a global community to really deal with an unexpected large-scale global health crisis, right? And even as key players in global biomedicine have, tried to make huge leaps and bounds for the production of vaccines, and we're still trying to vaccinate as much of the human population as possible. I think it's important that the law needs to respond as well, which is why we're very, very happy for all of you to be here and to be sharing your expertise on how moving forward countries can come together to put forward together very robust plans, having an ecosystem in place that will then be able to help us deal with issues like this. So to kick off, Professor Sarah Emami will be starting, and then followed by Professor Bridget Topes and then Professor Maria Varaki. I will be introducing each of them as we begin so that it would be like a fresh introduction before they begin speaking. Without further ado, I'd like to talk about Professor Sarah Emami, who's going to be with us speaking today a little bit, probably, I think, about the pandemic treaty, if I'm not mistaken. And the IHR as well. Now, Professor Sarah Emami has worked in international public health law and policy for over 20 years, and she was a legal officer on the Secretariat for Negotiations for the Framework Convention on Tobacco Control. She also worked with the Secretariat on the International Health Regulations. And in addition, she has worked on a number of other initiatives on communicable and non-communicable diseases policy and health systems with organizations like the WHO, the WHO's regional and country offices, the UN Development Program, and the Chatham House Center on Global Health Security. She's an adjunct professor at the City University of New York and American University. Without further ado, very much welcome you, Professor Sarah Emami, with your presentation.
Thank you very much. It's a real pleasure to be here with all of you. I want to preface my remarks by saying that all of these are in my personal capacity and they do not represent any particular government views. What I really wanted to give you today was a little bit of the groundwork for where we find ourselves now. WHO can be a complex organization and the procedures can be a little bit difficult to follow. So I thought it might be useful just to trace where we are now, how we got here, and what we can expect in the next few months as we hear so much about these themes, about a pandemic instrument, as we hear about amending the IHR, what these things are, what they really mean post-COVID. So I wanted to start by talking a little bit about the IHR. We use a lot of acronyms in this area, of course. So these are the international health regulations. The international health regulations have existed in some form since the late 1800s. They were Europe's response to the spread of communicable disease. They were taken under the umbrella of the World Health Organization, WHO, after it was established, and they were revised a number of times due to particular needs, changing disease priorities. But then in the early 2000s, there was really a call given the number of emerging infectious diseases, concerns about globalization, about cross-border spread of disease, for a larger revision of those instruments. And so WHO undertook these revisions between 2001 and 2003, and they gave us what we are working with now, which are the IHR 2005. So we have existed with this instrument for about 16 years. They provide an overarching legal framework that defines countries' rights and obligations and how to handle public health events and emergencies that have the potential to cross borders. So those things that a country might not be able to handle by themselves, those things that might pose threats to other countries. This is a cornerstone of our global health security framework for action. They outline the criteria to determine whether a particular event meets a certain bar. This is called a public health emergency of international concern, or a FIC. And how do they do this? They require countries to designate a national IHR focal point that is supposed to communicate with WHO, to establish and maintain core capacities for surveillance and response, including at particular points of entry. You know, what do you do at ports? What do you do at airports? And they also include safeguards to protect the rights of travelers with relation to the treatment of personal data, informed consent, and to make sure that any measures are applied with a non-discriminatory approach. So that's where we were. There were a lot of concerns that have been brought up during the lifetime of the IHR, as you can imagine, with the Ebola crisis most recently in West Africa in 2015. But as you can imagine, with COVID, there were some new criticisms of the IHR, some new concerns about how well they had been implemented, where their gaps were, the fact that, you know, as lawyers, we might be concerned that they tend not to have any teeth. There are a few measures for noncompliance, and the measures for resolution of disputes have never been undertaken. So there were a number of panels that were established after, or we are not after, but after the emergence of COVID-19. One of these was the Independent Panel for Pandemic Preparedness and Response. And they've noted the initial outbreak became a pandemic as a result of gaps and failings at every critical junction of preparedness for and response to COVID-19. Some of the problems that they identified related to the IHR. So these were about how fast the virus moved with respect to existing surveillance and alert systems, how early responses didn't have enough urgency, weren't effective enough, and what failures there were in sustaining the response in the face of the crisis. So that's sort of part one of what I wanted to say, in that is the architecture in terms of WHO going into COVID. Now, as the pandemic evolved, there were two key outcomes that I wanted to mention, and these were adopted by the 74th World Health Assembly. The World Health Assembly is the governing body of WHO, and it meets every year in May. So last May, in May 2021, there were two outcomes, as I said. The first of these was a resolution. This was resolution 74.7, publicly available for anybody who chooses to look at this on the WHO website. One of the things that this did was to establish a member states working group on strengthening WHO preparedness and response to health emergencies. That's a mouthful, so we will shorten that to WGPR for the rest of this talk. But they were essentially charged with looking at the findings and recommendations of 3 key review panels. So those were, as I just mentioned, that an independent panel on pandemic preparedness and response. We also had a review committee for the international health regulations and how they had been used to respond. And then the Independent Oversight and Advisory Committee for the WHO Health Emergencies Programs. So that was a big chunk of recommendations for this group to take on. That was one of their key responsibilities. There was another important decision, and here we come to the crux, I think, of this webinar, that asked the WGPR to prioritize the assessment of the benefits of developing a WHO convention, agreement, or other international instrument on pandemic preparedness and response, and to provide a report to this to be considered at a special session of the World Health Assembly. Now, this special session, being special, was not held in May. This special session was held last November, in November 2021. And what they did was to agree to establish a group, an intergovernmental negotiating body that all member states and associate members could participate in to draft and negotiate such an instrument. So this would be a WHO convention, agreement, or other international instrument to look at pandemic prevention, preparedness, and response. Now, this might be a legally binding instrument. The language says it could be adopted under Article 19 of the WHO, which, as many of you know, I'm sure it was the basis for the WHO Framework Convention on Tobacco Control. There are also other options under the WHO Constitution for adopting such an instrument. In terms of the timing, they said the first meeting of the INB, so the first meeting to start talking about this instrument will be held by the 1st of March. This deadline was met. And what they were charged with is identifying substantive elements of this instrument and then talking about the development of a working draft. And that would be presented for consideration of this group at its second meeting, which has to be held no later than the 1st of August, 2022. At that same meeting, that second meeting of the Intergovernmental Negotiating Body, they are charged with identifying which provision of the WHO Constitution the instrument should be adopted by. So this is, again, a reference to whether this will or will not be adopted under Article 19. As you can imagine, this is an issue of some controversy. And so the INB is asked to submit its outcome to the 77th World Health Assembly. So this takes us to 2024, to May 2024. So we are looking at about 2 years of negotiation, and we are now at the outset of that. So where are we right now? So there is a draft consolidated outline that you can find right now on the WHO website. This is under the WHO governing bodies, which has a section specifically on the Intergovernmental Negotiating Body. And this has this has a draft consolidated outline at this stage. So it's a very preliminary document, but this is publicly available. And this is sort of a combination of those many, many recommendations that the group felt were appropriate for consideration by this group. It is basically divided into 4 buckets. So these buckets are equity, financing, governance and leadership, and systems and tools. And so right now what we have is a catalog of measures that could be divided in these ways. So that's where we are in terms of the pandemic instrument. But I would like to circle back to the IHR, because not everything that is considered is going to be considered under a pandemic instrument. I mean, yes, we are talking about, I think, a lot of equity issues under the pandemic instrument, but we still have that IHR, and we still have thoughts about how do we strengthen the IHR? How do we make that part, the preparedness, the prevention part better, country systems better, country communication with WHO better? So to that end, we had a couple of developments at the session of the Health Assembly, which just concluded. So this was the 75th World Health Assembly. So there was a decision to have this process to consider forward amendments for the IHR. Are there amendments that could make the IHR better? Again, this is on a 2-year timeline, and the deadline is September 30th. And so member states are asked to submit proposed amendments by September 30th of 2022 in order for those to be taken up by the transformation of that earlier group into a working group on the IHR amendments. And also notably, there was adoption of one change to the IHR. This was to Article 59, and it essentially means that amendments can enter into force more quickly once they are adopted. So basically adjusting this from a 2-year to a 1-year timeline. I want to emphasize once more that all of these are my personal views and don't represent any government or other organization. And to say that I've shared publicly available information, all of which is available to the public via the WHO website. And with that, I'll close and open for any questions.
Thank you very much, Sarah. That was extremely enlightening, especially for people like me that, you know, I'm in the field of health, but like a small part. So this is just extremely enlightening, and we're happy to take questions right now. If there's anyone with any questions, please feel free to pop them in the Q&A so that we can read them out.
Yeah, of course, now shorter questions, because we're going to have also the opportunity for the audience to respond in the end in Globo. But actually also the other panelists now, maybe 5 minutes to have a short discussion before Professor Topes also continues. My first remark, Professor Emami, would be, okay, the WHO, the World Health Organization, how is it undermining, though, the whole UN system? Of course, the World Health Organization is part of the UN, but the whole question is it the appropriate organization to handle such an important issue? Or any pandemic treaty should be under the auspices of the UN General Assembly, maybe the International Law Commission. So this is my first comment. Of course, as an international law, not necessarily, as an international person, not necessarily focusing on health law, but also the other panelists can comment on this.
Please just let me know if you'd like me to take the questions and then respond, or just tell me how to proceed.
Can I
see Maria has a question as well.
Yes. First of all, thank you very much. Being a public international lawyer myself, and because we talk all this the last years, you know, that it becomes more and more difficult, you know, to conclude new legally binding treaties. You know, I was wondering, how do you see this effort? To what extent, you know, this is a kind of an exceptional moment that there is the will of the international community to conclude with a new legal instrument? Is it, how do you see that from inside? What is your feeling? Because we keep saying, you know, that it becomes more and more difficult, and we go into soft law instruments more and more. We talk about compacts, we talk about non-binding legal instruments. So what is there? Which is it something exceptional? Is it a turning point? How do you assess that? Thank you.
Would you like me to proceed with these two questions? Okay, so thanks very much for both of those insightful questions. The first is about the relationship of WHO with the broader UN system. So WHO, of course, is a technical agency of the WHO. I'm sorry, WHO is, of course, a technical agency of the United Nations. I think it is a question for member states whether a particular issue is within the scope of WHO to take on. I don't think that there was any question, for instance, that the IHR are appropriately situated within the WHO. But of course, there have been broader attempts that have been situated elsewhere. And I think that there has been a little bit of discussion about the appropriate place for a pandemic treaty. And I would say that the answer to that is what is going to be covered in the treaty. And that is not something that we know right now. So I hope it doesn't sound like I'm dodging the question, but I would say that is something for, UN member states, or WHO member states, and they should make the decision about the appropriate venue. I think that, if this exceeded the scope of WHO, then we would talk about where it belongs. But I think we need a little bit more of a concrete idea about exactly what is going to be housed in this instrument. And then moving on to Professor Varaki's question, how do we see this effort proceeding? Actually, my answer would be very much the same, that we need, I think, a discussion and an agreement from member states about exactly what they want to cover in this instrument and what the most appropriate form for that is. I didn't mention it, but I think it was a March 30th, 2021 editorial by 30 heads of state that was published in a number of international newspapers about, the call for a pandemic treaty. And I think there's a legitimate question. Do we want a treaty? Do we want a political declaration? Do we want something that is both? Again, I'm not giving my opinion on what there should be. I think we need to decide, what do we need? Do we need political commitment? Do we need resources? Do we need, if we need better bilateral or multilateral sharing of resources, what is the best mechanism for that? And I think there's a lot of useful work going on. How has COVAX worked? How has Act A worked? What exactly are the supply chain issues that we are having? How exactly can we best support local and regional manufacturing to ensure that those don't happen again? And then once we have those answers, I think we need to say, well, what is the most appropriate instrument and how can WHO support those? And not in any way to detract from the effort, but there are a lot of authorities that WHO has. And by authorities, I don't mean anything that infringes on national sovereignty, but I mean the ability to step in and to provide requested cooperation and coordination to member states. And to facilitate mechanisms like COVAX. So that I think that would be my answer. This is, as we all know, a challenging time for multilateralism. So I think we need to just see where we are. We are in extremely early days. I mean, we are talking about a 2-year process, and I'm with a panel of international lawyers. You're well aware that 2 years is an incredibly optimistic timeline for any piece of international law. So I think we just need to keep on top of this, follow along with it, and see where we get to.
Thank you so much, Sarah, for this. Do we have any follow-up questions from the audience, perhaps? If not, Sarah, I know you're a little bit short for time, but I'm interested to know your opinion about one tiny little thing.
Sure.
Really, I'm interested in knowing about, this whole, the INB, the negotiating body thing, right? From the understanding, it is hoped that this would be a much more participatory process, right? And I'm wondering if you think, for instance, the role of civil society and nonprofit organizations for fractions, possibly, of people who might be affected on pandemics on a larger scale, especially when it comes to access and inequalities, and how important do you see the role of these civil societies in the participatory process?
again, as a lawyer, I will say I am responding with my personal observations here. I think that this is extremely important to a lot of member states. I think that we have heard a lot in both the WGPR, so that first process, and the IMB about the importance of civil society and engaging other stakeholders. And I think there's also an aspect to involving private sector stakeholders who have a role in supply chain issues, in meeting demand for medical countermeasures and related needs. As you know, there are public hearings that are mandated as part of this process. So the first of those, I believe, was in about mid-May. And I think there will be some further ones throughout the process to ensure that those kinds of viewpoints are being incorporated. I think that, a lot of member states are also very keen on soliciting these viewpoints and making sure that they're part of their participation in this process. So I do see stakeholders as playing a major role in this process going forward.
Thank you very much again, Sarah. If there are no further questions, then we'd be happy to wrap this up. Sarah, thank you very much once again for being here with us. And right now, we're very happy to move on with the program as well. I'm very happy to introduce to you Professor Bridget Topes, who is with the University of Groningen Faculty of Law since 2012. And since September 2018, she's the Chair Health Law in a global context at the Department of Transboundary Legal Studies. And also from 2013 to 2018, she was the Associate Professor and Rosalind Franklin Fellow at the former Department of International Law. And now her research focuses on international health law, and she established the Groningen Center for Health Law, and a research center that really addresses the intersection between public international law and protection of health, very much what we're interested in today. And she also teaches public international law, international health law, and human rights law. She advises on a variety of governmental and non-governmental bodies on international law dimensions in their research and on public health policies, also the WHO and the UN Special Rapporteur on the Right to Health. Without further ado, Professor Bridget Topes, we're very happy to welcome you here.
Thank you very much, Pin. That's a lot of information about myself. For those who don't know, Groningen is a city in the north of the Netherlands, so don't confuse it with Göttingen, it's Groningen. It's really a pleasure to be here, and I've enjoyed listening to the previous presentation, so thank you for this opportunity. And my contribution is based on a report that I wrote together with my PhD candidate, Megan Beyer, for the Royal Dutch Society of International Law. So much for royal, but okay. We talk about global health law as a field, as an emerging branch of international law in this report. And we say, well, it's to some extent unknown territory. There's some uncertainty about the nature and scope of this field. And what we also see is that the COVID-19 pandemic has generated wide interest in global health law. It has affirmed that health is an important value in international law. And it can, for example, counterbalance conflicts with the interest of global trade and economic liberalization. So what is global health law? And that is the goal of this presentation, to sketch the field and discuss some of its dimensions. Two preliminary questions. You've heard the term international health law and global health law. So what is it? International health law is probably the older term and was used initially to refer to the standards addressing infectious disease control. It's consistent with existing terminology in international law, for example, international humanitarian law, international trade law. And global health law, on the other hand, reflects possibly a more expansive interpretation of global health. It's suggested to address the world's community as a whole and not only certain nations. The term decolonizing health is also sometimes mentioned in this context. It's also considered to address or to better address non-state actors. Now, that's one, and I welcome your views on this. And then the other preliminary remark is, we suggest in our report that global health law is an emerging branch of international law. What does that mean? When is a set of international rules a branch of international law? Should it be coherent? Can it be fragmented? Should we be able to identify certain characteristics? Do we, for example, need a minimum amount of binding rules? Well, I look forward to hearing your views on this as well. And then if we study global health law, then possibly the first step is to look at it through the lens of Article 38 of the Statute of the International Court of Justice, identifying the sources of international law. Well, of course, then you can question again, how authoritative is Article 38? For example, it doesn't mention soft law as a source of international law, while soft law in global health law is very prevalent. I'll come back to that in a second. In our contribution, we've reflected a little bit on this. We make an attempt to, for example, talk about what could be customary norms of global health law. And we suggest, and my colleagues fiercely disagree with me on this, but we suggest that certain conduct exists in domestic health law that could also qualify as international practice. And what could that then be? Things like autonomy, confidentiality. Let me know what you think. And then also we talk about general principles. And we have suggested that such principles can also emerge internationally, as other scholars have also suggested. And could it be principles like equity, solidarity, proportionality that also exist in other areas of international law? Soft law. Article 38 of the statute doesn't cover it. But in global health law, we see a broad range of soft law standards with varying levels of authority. Some examples include the WHO Code on the Marketing of Breast Milk Substitutes, the guidelines of the Convention of Parties of the FCTC, the Framework Convention on Tobacco Control, but also, we would argue, general comments of the human rights treaty bodies. It's important to analyze the role and influence of these instruments and to balance their weight against hard law instruments. In any case, soft law cannot be overlooked. More and more actors now interact with the law, including soft law. And take this by way of an example, how cities engage increasingly with environmental protection. There are different definitions of soft law in the literature. I'm not going into that. My colleague Marcel Brus and maybe other scholars as well have suggested that there's this continuum between soft law and hard law. And I think it would be interesting to study where do the various instruments under global health law, where do we place them on this continuum between hard and soft law. Then the standards adopted by the World Health Organization was already touched on in a previous presentation. And what we argue in our contribution, that's widely recognized, that the core of international or global health law is constituted by the standards adopted by the World Health Organization. Based on its constitution that was adopted in 1946, WHO has considerable standard setting capacities. It can adopt treaties, binding regulations, and recommendations. But we also know that the outcome here is very disappointing because over the past 70 years of its existence, WHO has barely made use of its standard setting capacity. It has adopted one treaty, the Framework Convention on Tobacco Control, and it's a shame that Ellen Taylor is not here because she really stood at the cradle of this treaty. WHO has adopted 2 regulations and a broad range of recommendations. Why so little law? Now, one explanation is that there were not so many lawyers working within the WHO. The other one is that health was considered for a long time a domestic issue. Well, we all know now that it is not, right, after the COVID-19 crisis. So the weight and impact of the existing standards are huge. I'm talking here about the FCTC and the International Health Regulations. FCTC regulates a risk factor for non-communicable diseases, tobacco, and of course the International Health Regulations are to ensure that member states take measures to prevent and control the outbreak of infectious diseases. A few words about the FCTC without going into detail. What I find interesting also about the FCTC is that it unlocks the potential for regulating other so-called risk factors for non-communicable diseases. We are currently talking a lot about infectious diseases, but globally, most people die from non-communicable chronic diseases. And we also see how infectious and non-communicable diseases are interconnected. It is commonly known that 4 risk factors, this is also what the WHO consistently says, 4 risk factors are at the root of chronic diseases: smoking, unhealthy diets, excessive use of alcohol, and lack of physical exercise. So what we now have is a treaty addressing tobacco, but we don't see a treaty for unhealthy diets and alcohol. I recognize that regulating diets, for example, is hugely complex, but I also suggest that it's important to have the discussion about the possible content of treaties on diet and alcohol on the table, and to see if political will can be generated to adopt such treaties. Then there's also the International Health Regulations, rules in relation to infectious disease control. I'm very glad that the previous speaker spoke about international health regulations and the pandemic treaty. I must say I find it a very complex discussion, and I also find it difficult to come to grips with what is the pandemic treaty about and how does it complement the international health regulations. Then the third possibility for the WHO is to adopt non-binding recommendations, Article 23 of the WHO Constitution. And a crucial example here is the Code of Marketing of Breast Milk Substitutes, which was adopted already in 1981. I found some research suggesting that around 70% of member states presumably has adopted legal measures to adopt the code, but there is at the same time ample evidence that baby milk companies still see many ways to market their products excessively. And so this begs the question, what is the value of this code? Would a binding instrument be more effective here? What is the role of soft law? Going back to that, is soft law the glue of international law? Is it sometimes as good as it gets, or should we opt for something stronger? What we also see, and I find that truly interesting, is an increasing integration between these WHO standards and human rights. And it's increasingly argued that states are required to implement WHO standards, for example, the WHO code, the BMS code, as part of their obligations under the right to health. And that brings me to human rights. We argue in our contribution that human rights play a foundational role in global health law. We argue that human rights reflect a range of important values that are the fundament of global health law, such as dignity, well-being, and health. And at the very core of these human rights standards is, of course, the right to the highest attainable standard of health, in short, the right to health. Now, the right to health is an economic and social right, as opposed to the civil and political rights. And on paper, we have recognized that both sets of rights, economic and social and civil and political rights, have the same status, but in practice, of course, it's more problematic. If you go to a Dutch court, for example, and you base your claim on the right to health, you are very unlikely to be successful. But we have at the same time see that implicitly the right to health was at the core of all the public health restrictions that were taken during the corona crisis to curb the outbreak. In essence, this crisis has been very much about balancing protection of public health, the right to health, if you like, against civil and political rights such as privacy, physical integrity, and freedom of movement. This is a very difficult delicate undertaking and balancing, but it shows the importance of human rights in the global health law field and the need to come to a better understanding of this balance. Now, human rights play a role in many health-related concerns, varying from access to medicines, climate change, and so on. And one area that I would like to mention very briefly, where human rights are key, is the area of reproductive health of women. International human rights standards do not explicitly recognize the right to an abortion, but there is by now a rich body of case law at the international and regional levels recognizing reproductive autonomy of women and the protection of their health. And what is a pivotal step, I think, in this field is the adoption of General Comment 36 of the Human Rights Committee in relation to the right to life. I think it's a breakthrough because here it says that where the life and health of the mother are at risk, states must provide an abortion. This is how I read it. And again, I think this is a breakthrough. Then some last remarks about regime interaction. I've discussed the standards of the WHO that constitute the core of global health law. I've talked about the importance of human rights in global health law. And in our report, we also discuss how several other branches of international law are relevant to the protection of health-related concerns. The international drug control treaties, for example, international humanitarian law, international environmental law, as well as international economic law in its broadest sense. And the debate about regime interaction runs as an important thread through our report. And the basis of this is the principle of systemic integration, which emphasizes the unity of international law. Treaties should be interpreted contextually by taking into account their broader normative environment. And this is, of course, grounded in the Vienna Convention on the Law of Treaties. And we observe in our reports that this can lead to both synergies and tensions. We see synergies between the right to health and the WHO standards. And there are parallels between these standards and international environmental law, international humanitarian law. For example, the standards under international humanitarian law could color in the right to health in its application during armed conflict. But there are also potential tensions, for example, between standards under international trade law and the FCTC and right to health. After all, trade is not necessarily good for health. But what co-author Megan finds in her research is that international trade law generally protects bona fide health measures. And an important example concerns the dispute launched before the WTO concerning Australia's Plain Packaging Act. The outcome was that Australia's law was not inconsistent with international trade law standards. So states can actually go quite far in adopting measures that have an impact on the free flow of goods. But, and this is also Megan's point, there is still room for further integration of relevant rules, such as human rights with international trade law. So altogether, this is how we can perhaps perceive global health law, a set of standards from the WHO, human rights, and related standards constituting both synergies and potential standards. I come to my conclusion. So what is global health law? I raised the question also to you. Do you think it's a coherent undertaking, or do you think it's a more collection of problems? I hope that I have convincingly shown to you that global health law, fragmented as it is, merits attention, and that it is something that is worth studying and perhaps fighting for. And important challenges for the future are the further integration between the standards, the development of new standards, and also understanding the role of soft law. Thank you very much for listening.
Wow. Sorry, Solon, did you wanted to say something?
Please, no, please, if you have a question, I have Professor Topes raised so many important issues. I have two brief questions. I think it's more than 5 minutes, and afterwards in the Q&A section, maybe we can speak more about this. But Dr. Lau, if you have something to say, please take preponderance.
Yeah, I think I will also ask the questions in the Q&A, and we would like to give preference to anyone in the audience right now who might have any questions they want to raise?
Yes, and of course, still we wait for the audience. Now I will ask this question to Professor Tebes. You mentioned confidentiality. So the question is, how can we make confidentiality international law principle? And the second question is, that is linked to the first one, do we need to make health law an international branch, international law, or is it enough to make it transnational law? Why do we need to have the urge to make it international? And is it possible after all? Maybe we try to invent the wheel after all, and maybe we were going to undermine the essence of international law itself by trying to artificially create new branches of international law.
Thank you. I really love the question. I think it's great points. If I were to argue in favor of global health law, I would say health is an important matter of international concern that we have seen in the COVID-19 crisis. You are suggesting that it may complicate matters, and we already have these principles at the domestic level, and we have them transnationally, as you suggest. I think that's also an interesting thought. I have no clear answers to your important remark, but I value the question very much. I take it on board.
One of the participants is asking, Bridget, if you might be able to share a link to the report that you have prepared as well.
Yes, I can do that.
Yeah.
Oh, do you want me to do that now? Now you're asking a high level of technical skills from me, which I have not, but I will try to. Oh, I think I have it here. Yes, okay. I will try to share it in the.
Yeah, in the chat if you can.
Wow, I'm really proud of myself now.
I see Maria also has a question. Maria?
Yes, because unfortunately I will have to leave by 5:15, so I want to make sure, you know, I have your answer. I raised my question. I found very interesting, and you will see also from my short intervention, you know, your reference to human rights law, of course, you know, and I was General Comment 36 about the right to life, and of course, you know, over there the members of the Human Rights Committee applied system integration. You know, they made it very clear, you know, that was what they did. But then what is very interesting, I think from it, the general comment is fascinating in many respects. It touches upon many issues all over international law. But they talk about the right to life as the right to live in dignity. You know, and for me, it's the first time that I see a general comment coming from the Human Rights Committee. Okay, of course, we talk about connection and everything, you know, but it really ties civil and political rights with social justice, you know, what it means to live in dignity. That's the first thing, you know. And the second thing is, again, it's the previous question I raised, you know, to Sarah, because you mentioned, you know, that soft law within health law, global health law is very important, you know. So that's why I'm intrigued by the suggestion of a new treaty, you know, and I try to understand what that might mean, you know. Does it mean, you know, that are there repercussions for the idea of soft law within international law, that it is important? Of course we know it is, but it's not enough because it doesn't trigger this kind of strict normativity we want? Or is it like this emergency thing and this panic out of this pandemic, you know, that the usual response is we need a new treaty, we need new law, you know? So I try to understand, but I don't know. So I stop here, you know.
I agree. I don't know either. But isn't it a bit telling that we are all very confused about it? And so apparently nobody has been able to explain to us very clearly what this treaty is about and why it is important. We work in the field, we don't understand it. But it might be me. But okay, I'm trying to come to grips with this process. I also get the impression it's very political, and there's various groups trying to push it, and there's also competition between these groups. So how useful is this?
But I think this is the best now kind of way to enter Dr. Varaki's also presentation, which will speak about human rights, and we'll try maybe to bridge these issues.
Yes, thank you very much.
Thank you. Sorry, I don't know if. Yes, I'm waiting.
Oh yeah, please. So I'm very happy to introduce now Professor Maria Varaki, who is a lecturer in international law at the very interestingly War Studies Department of King's College, London. And before moving to London, she was a senior research fellow with the Eric Castren Institute of International Law and Human Rights in Helsinki, and worked on an Aristotelian theory of ethics for global governance. And before that, she was also an assistant professor in international law. But I'm very happy right now to welcome Maria. Please proceed with your presentation. We're very happy to hear from you.
Thank you very much. Thank you very much for the very kind, first of all, invitation. Thank you very much, Solon, and thank you very much, Pin, for the very kind introduction. So then when I say stop, because let's talk about. So I'm not an expert in global health law or transnational health law. I'm an international lawyer who happened to do recently work on virtue ethics and ethical leadership. And here, I think I will try to invite the participants and all of us, about maybe a different understanding about that. It's very much, I will talk about solidarity. So speaking, about principles, Bridget, or standards, I want to share with you some of my thoughts, because I started a couple of months ago slowly working on the concept of solidarity. I'm trying to understand what it is, this concept of solidarity, within, and I contextualize it within the framework, of the pandemic, of the last pandemic, and of vaccines, of equitable distribution of vaccines. So I will, being Greek, Solon knows that as well. We try sometimes, we show off by using all these Greek words, but I have to say that something that inspired me very much, it's from Antigone, from Sophocles. It's all about natural justice, it's about human nature, it's about the tragedy of human nature, right? The conflict between the laws of natural justice and the laws of man. So there is a famous ode to man. And there, I'm going to not show off, but I will mention that in ancient Greek, and then I will give you the translation. It says, "Πολλά τα δεινά που δεν ανθρώπου δεινότερον πέλη." So a very simple translation is, manifold the uncanny, yet nothing more uncanny than humanity moves towering beyond. So basically this phrase says that the human nature is capable for the best and the worst. It's capable for destruction, but also for creation. It's capable for the marvelous. It's capable for the ugliest thing. And this is how I approach the concept of solidarity here. Now, as we all know, the last 2 years, apart from all the apocalyptic headlines about, the COVID and conspiracy theories and everything, the latest pandemic, for a variety of reasons, address fundamental issues of global justice. It is also an issue of global justice, whether we approach it, from a human rights perspective or from other perspectives of trade law or IP. It's an issue of global justice. And what is very, very interesting is that the whole discussion about whether we can have effective vaccines, who will have access to these vaccines, how the COVAX project that was mentioned before briefly, is operating, which is also a collective effort. All these issues, they raise ethical, policy, and legal issues. Now, I am addressing, we are lawyers, we are lawyers. So what I found very, very fascinating was that the initial reaction to the pandemic was all about law, okay? It was like, we need more law, and it was more about accountability. It was about responsibility / accountability. Who is accountable for that? Was it the particular states? Was it particular the national organizations? Where could we fill the accountability gap, right? We talk about, we have an issue of compliance. What did it go wrong? We didn't talk a lot about the politics, because the majority of lawyers were afraid of touching the word politics, but we knew, we all know, Bridget mentioned that before, like about this treaty. It's all about, we are talking about this interrelationship between politics law. So I was intrigued by this response, providing the international health regulations. I say, we have a violations of this article, we have a violation of that, we have a violations of the other thing. And then at the end of the day, and I was wondering, and so what? I don't want to be dismissive, but I say, okay, we acknowledge, we highlight the violations, but what is this plus? And then I started thinking about the concept of solidarity, which is not a new principle. I'm not going to reinvent the wheel. We know that solidarity exists in different parts, components of international law, apart from as a constitutional principle in domestic law. But we have seen it with international refugee law. We talk about now within the context of climate change, but also the right to development with the SDGs goals. So solidarity is everywhere. What I found, though, very, very intriguing again was an attempt of legalizing solidarity. Again, we lawyers feel the need, to make a legal provision. There is a duty to solidarity. So we have an independent expert under the mandate of the UN human rights system, which is an independent expert on human rights and international solidarity. And if you check the website, of the particular mandate, you will see also, most likely, that we have also a draft declaration on the right to solidarity. So already, we talk about this language of human right, that it is a right to solidarity. We don't talk about, we move from the concept that Bridget talked about, from the principle, from the general, and we start using the right language. So the mandate says, I'm sorry, I'm trying to find exactly that. International solidarity is the expression of a spirit of unity among individuals, people, states, and international organizations. It encompasses the union of interests, purposes, and actions, and the recognition of different needs and rights to achieve common goals. International solidarity is a foundational principle underpinning contemporary international law in order to preserve international order and to ensure the survival of international society. And if you go to the draft declaration on the right of solidarity, you will see that it has three main components. One talks about preventive solidarity, the other one is about reactive solidarity, and the third component is very much about international cooperation. And it's very true that during those last years, we hear about the need of more international, for more cooperation and more sharing, burden sharing, more and more and more. However, a year ago, apart from this draft declaration of the state on the right to solidarity, I showed a report by the UN independent expert about solidarity and the pandemic, what's going on, especially with regard, to equitable distribution of vaccines. And there the independent expert made a claim using the language of the draft declaration that the issue of solidarity raises both legal and ethical questions. And for me, I would, and of course, when it came to the ethical question, he was talking about Martin Luther King. I expected something more of Kant, but it was not there. So I didn't see an actual ethical foundation. But when it came to the legal normativity, I was not very convinced, to be honest, because if you give me the UN Declaration of Human Rights, or you give me, some particular references from the UN Charter, and I'm a doctrinal lawyer, I'm not someone who is going to say, no, that doesn't matter. I believe in customary law, but I'm saying, that by listing particular provisions, that says Article 55, 56 of the UN Charter, or the UN Declaration, and then you give me some more articles, of the ICCPR and the ICESCR, that it was not legally convincing, and different other provisions, to establish that we have a separate right to to solidarity. So I'm going to stop now within the next 2 minutes. So I challenged myself and I thought, how can we deal with solidarity in a more cautious way? How can we rehabilitate solidarity without falling in the trap of this strict legalization? Why should the answer always be a strict legalization? And we have seen also, about the duty, the legal duty to do things that several times states, they don't do anything, they sign, ratify treaties, and there are many, many ways where states do not do. So is the answer another right, to put it simply like that, another legalized right? And there, my proposal, and I'm at the very beginning, of my project, is that I propose, that solidarity may be considered as a concept that has a fluidity. I call it agnostic solidarity. So we don't need to give a determined content on solidarity, because solidarity is a constantly evolving sensibility, and sensibility, you know, that depends on several actors and several factors, and can involve and can engage many actors. This is something that I have to acknowledge also with the special rapporteur, that he doesn't talk only about states or international organizations, but also about non-state actors and other actors in general. So my proposition, in order to explain a little bit more about this understanding of agnostic solidarity, I suggest, you know, that if we do not give a predetermined content in understanding of solidarity, then solidarity can operate, as I say, as a cathartic tool. And it's a cathartic tool because if we let it guide us where it goes, then we can explore also potential things, but also limits. And how am I going to do that? Then I'm going to, you know, to draw on my work with young clubbers of ethical leadership, and I'm going to use, you know, ethical paradigms of particular leaders, of particular individuals, of particular international civil servants, how they behaved, how they, during these 2 years, what they suggested. We know leaders, you know, who suggested the waiver of IP patents, you know, when it comes to the vaccines. We have other leaders, you know, who behave the opposite way. We had the UN Secretary General who we can identify, you know, in his statements, you know, some particular behavior. So, you know, and I have to stop here. My suggestion is that we can define, we can address solidarity. We can try to understand solidarity on an ad hoc basis, based on the particular cases or particular individuals, how they behave, what kind of exemplars they are, and to what extent, you know, if we have, like what it was mentioned before, for example, that there was an editorial call for a treaty by 31 leaders, if I say, or people who behave in a particular way, to what extent, you know, ethical paradigms can actually also trigger developments in the legal normativity on the legal front. So I would say, you know, that my understanding of solidarity is not a legalistic solidarity, it's not even a legal solidarity. I don't believe that we need another right to solidarity. I believe that we need to use the solidarity in a way that can contribute to minimize injustice. And I stop here. Thank you very much.
Thank you so much, Maria. I'm very mindful that you have to leave in about 10 minutes. So can we please, audience, we're very happy to take any questions that you may have for her. But if you don't just yet, Maria, oh my goodness, I have a question for you. And it's not a legal question, as you've mentioned, because thinking about the word solidarity, it seems like we're really looking at an idealistic set of values, really, values that underpin our understanding of human rights, about public health and things, for instance. So, and I think one of the things that you mentioned, which really struck me, was about using the right kind of language. And I like that you used the word agnostic solidarity, and also about the possible ways of what is encompassed within this agnostic solidarity. So if I just can like poke the bear a little bit, I think one of the things I was just thinking is that it becomes so important to identify really what the content of this agnostic solidarity might be, because we hope that, of course, it strengthens bonds, it brings people together, and in an ideal society, everything makes it all very nice, right? But if we think about societal or society's solidarity, that may not always be in alignment together with, say, a political solidarity, which might be necessary sometimes in public health crisis. So how do you see this particular type of conflict, or I don't know if it's a conflict, but this kind of interaction that might take place when we have different ideas of solidarity, and how we can sort of safeguard public health in this respect? Sorry, it's a bit of an abstract question, but yeah.
Thank you very much for that. Yeah, it's very true, and that's why from the beginning I found it, if I can say, problematic that we go there. There is a presupposition that we have a unanimous understanding of solidarity. I'm in a small project with 4 more colleagues, and we do a kind of compare. And I'm doing the international law, and there are others more of constitutional comparative law, and it's striking to see how different it is. In regions, countries, and within the same society, as you say, within the same society. I think I will try for a modest and moderate, because I know it's very, very tricky. So what I'm doing at this stage, is, as I said, and maybe I didn't explain before, I'm comparing behaviors within the last 2 years, and try to compare how different individuals reacted, and how that was perceived internally, domestically, but also internationally. So of course I cannot compare everything, but I can say, that depending on the context, acknowledging, that we are talking about different contexts, okay, that behaviors, for example, I can tell you this waiver of the international pattern of the intellectual property rights, for me it was quite striking to see our Prime Minister Solon, to support this proposal very, very much, to support this proposal together with Professor Moschalos from LSE University. They were the first ones who wrote, an op-ed that they say, we need proper solidarity. We have to go for IP waiver, when it comes to that. And then that triggered a further discussion. I'm not suggesting, that they were the best, but I'm suggesting, what I'm trying to, that within the international context, you could see particular behaviors that trigger development. That's what but it's a very modest approach. It's a very modest, acknowledging that different societies and within the same, it's a multi-layered approach. And that means, that it requires also from the different leaders and from different senior people to understand the nuances of what we talk. It's a different thing to address solidarity, for example, in a developing country with a particular social culture and everything. It's a different thing to talk about solidarity within the EU. So these are things, that need to be addressed. I don't know if I responded, but I acknowledge all the difficulties. Thank you.
Thank you so much. Do we have any further questions?
I don't know if Professor Tebes, do you have any remarks to Dr. Varaki's comments and presentation?
I've really enjoyed listening to your presentation, and if I can play the devil's advocate, what's wrong with suggesting that maybe solidarity is an emerging general principle of international law? What's wrong with, if you study behavior, are you then in essence studying state practice that maybe contributes to customary norms? Those kind of thoughts crossed my mind, but I was very open to your broader reflections, which also questioned my approach, or maybe somewhat rigid approach sometimes to international law.
I don't know. Well, you see, I have to be very careful with that, and say that I don't think it's wrong. I think it raises some kind of expectations that do not reflect reality. Like, we have this tendency, maybe it's also my background being an international criminal lawyer, and, and I that always the answer was like, we give law and we give the answer, and then we see that it's not the law, it's the application, it's many more things. So I say, let's reverse the order. Let's see, I go back to state practice, but I don't exclude legal normativity. I say, this type of state practice can trigger legal normativity, but in a reverse order. If, we don't set the standards first, we see how it can be, and then we say, you see, there are some standards over there. I'm saying, that our answer should not be, okay, we need more provisions, okay, maybe we need a new treaty. These are the health regulations when we don't have any impact on the ground. I don't know if I make it clear. I'm suggesting that maybe, and I believe in law. As I keep saying, I'm a doctrinal lawyer. I believe in law. I'm saying, though, that we should try to create law that, I don't want to say that matters, but I don't think that if we have another treaty, let's say, or another regulation, without having a different mind, that will contribute to anything new immediately. Of course, we know how law operates, norms, and we talk about crystallization, we talk about different things. But I would say maybe, we can see it the other way around, and we can see, how particular behaviors and practices, can generate this discussion for a different understanding of solidarity. Because I'm afraid that if we talk about all the time the right to have a new human right, but let's avoid that. Let's give solidarity space, and maybe that will be more imaginative, and maybe that will be actually more effective. I don't know. Maybe I'm trying to think along these lines.
Dr. Varaki, I agree with you in principle that adding just a right is not enough. Must enforce also rights. But my question is, and my thoughts, that if we have a chance of ever reaching the enforcement stage, is it not by having rights vis-a-vis obligations which don't have teeth? And I remind you also about the European Union, the refugee issue, the issue of solidarity when it comes to the Syrian refugees in the European Union. It's only by trying, that's why the European Commission tried to put a quota, a legal binding measure for states. Otherwise, states were not ready to comply ethically just with taking in refugees.
Yeah, but I agree with you that. But my point is that if we go into the European concept of solidarity in refugee law, we will see how problematic again it was. Can you hear me? Sorry.
Yes, we can hear you, yes.
Hello, can you hear me?
Yes, we can hear you. The image is a bit frozen, but we can hear you. You can continue speaking. Now there is an issue maybe with the voice. Now there is an issue with the acute transmission of the voice. I think by all ways we have to wrap up the discussion in a few minutes. Just to say again, as Dr. Lau said before, for the audience, the last question, the last call, Dr. Varaki, now we are with us again. We said to the audience, last call. Now they have 3-4 minutes to pose in the last questions they want the audience, and to hear your final remarks and the final remarks of Professor Toebes, and to wrap up the discussion.
I apologize, my internet, I was disconnected, No, I'm not saying that. I'm just saying, that there was a wrong conception about solidarity as a principle per se, without a stick. We thought we have this principle of solidarity and it doesn't work. I'm sorry, but it doesn't work within the refugee law component. So this is where I say, let's think solidarity in different ways. And then we are going to see that. Solon and the others, I don't think I have the answer. I'm trying to say, that we can have many provisions, many norms, we can legalize things, and we can have no impact if we don't have an application. And the application does not happen, out of the blue. The application, happens by individuals at the end of this day. So that's what I'm saying. Thank you.
Thank you very much. And I think we are almost drawing to a close right now for the program. I'd like to invite any participants with any further questions for both of our panelists who are still remaining here right now. Yeah, sure, Maria, please. Maria has to leave right now. Thank you so much for being with us. Do we have any further questions? I don't see any in the chat just yet.
Along these lines, maybe Dr. Lau, to wrap up the event, also to say to the persons who are here in the audience, of course, to our dear panelists, that the next event of the BUL International Law Group is on June 27th on Children International. It's going to be the last event for this year. We wish you a further nice afternoon, and we thank also Professor Toebes, Dr. Varaki, and all the panelists who were here.
Thank you very much for being with us today. We really appreciate it. Have a fantastic evening.
Thank you very much. Thank you very much.
Bye-bye.